Hello, this is Matt on the Moon Lambo channel. Over the last couple of days, there have been two separate documents filed having to do with the SEC and Ripple situation. And the document that was filed yesterday, a supplemental document, may be just enough to push us over the line, says one popular attorney within the XRP community, thinking that it may finally be just what we need to get this whole thing finally wrapped up. Also, a separate XRP community member attorney did a great job of putting together a list of exactly what has happened and what needs to happen for this whole thing to end. So I think there's some confusion about what a bit of the last couple documents actually mean. So I want to get that cleared up, and then you can also, because I was probably wondering, okay, what's the timeline for this going to look like? And I think that we can actually finally see the finish line. But before going any further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so here's the first document that dropped, and this was on Monday, June 16th, and this one shouldn't have been a surprise for anybody that's been paying attention. This was shared by attorney Filan. Shout out and credit to him. He's been consistently sharing every document that's dropped literally for years now. So much appreciated. We're at finally at the home stretch here. And so here you can see on Monday, he wrote, let's see, XRP community SEC v Ripple. XRP, in light of the pending motion for an indicative ruling, the parties have requested that the Second Circuit continue to hold the appeals in abeyance with the SEC to file a status report by August 15th, 2025. And so that just means, as far as abeyance, it's just, temporary disuse suspension. We're in limbo, effectively. And so given that there was a deadline here, it shouldn't surprise anybody that that was the case. We did get something extra, though, and this one we didn't know was coming. This was yesterday, Tuesday, June 17th, also shared by attorney Filan here. He says, Ripple has filed a supplemental letter in support of the motion for an indicative ruling. Now, this is interesting here because, again, we didn't know that this was coming. This is supplemental. Now, the last document that was filed by Ripple on this topic, many attorneys viewed as a bit lackluster, noting that it was strikingly similar to the one that was even just before that, which probably, at least possibly, wasn't going to be enough for Judge Torres to go along with any of their new thinking on this, which would be a concern if you want to get this thing wrapped up. Because, of course, the SEC and Ripple agreed to a reduced fine. Instead of 125 million, they agreed to 50 million. They agreed to get rid of the injunction against Ripple that would make it harder for Ripple in specific situations to sell XRP. They agreed. But Judge Torres, needs to sign off on that, all right? And so here, the supplemental letter was an opportunity for Ripple to kind of make their case as to why Judge Torres should go along with this. And here's what attorney Fred Rispoli of the XRP community had to say on this. And it was a short document, 1.5 pages. So he says at 1.5 pages, this is not the strongest attempt, but it's an attempt. This concisely addresses three issues that were so obviously unaddressed that Ripple finally realized it had to say something. Number one, the district court isn't the end-all of the case. Appellate courts are. And this ends appellate risk. Number two, nothing is really being changed by dissolving the vanilla injunction. The summary judgment ruling remains, and Ripple cannot break the law regardless of the injunction. And so, folks, to be clear, with the injunction, it's just the reason Ripple wants it gone. It's obvious. It's because it makes conducting business a little bit more annoying and difficult. They can still sell XRP, but they have this ridiculous situation that applies only to them and none of their competitors. And it's just so there could be specific partners that where it should be perfectly fine for them to sell to it, but they legally can't because of an injunction. Like, make it make sense, folks. Like, that has never made sense. But that's the injunction, that's the ruling, right? As it stands now, that's the ruling. So doesn't matter for us as XRP holders, or, regular day holders like you and I. But for Ripple, yeah, it could be a little bit irritating. And then number three, Ripple is only in this situation, as opposed to the majority of other SEC targets, but SEC chose Ripple years before its attacks on the other industry players. And then he wraps this up by saying, I'm still underwhelmed but feeling more optimistic. This may push us over the line. So, frankly, I will just say this. They probably should have just included this in the last document on the topic that they filed. But since they didn't, I'm glad they filed it. And Attorney Rispoli thinks that this may be just enough, maybe to get Judge Torres to go along with this thing. And so here's a post from Attorney Bill Morgan, because there's been such hype and misrepresentations of what's going on with each of these documents over the last couple days. It seems to me that Attorney Bill Morgan, for good reason, easy to understand why, got maybe a little bit irritated with some of the stuff that some people were posting here. And so he wrote here, I was tired of dealing ad hoc with the false hype of XRP influencers misinterpreting and sensationalizing what is happening and each step in the court matter, so decided to summarize the whole settlement process, which I'm going to show you in just a second here, and I appreciate that he did this, and it does provide some clarity, so I'm happy to run through that. But here are a couple examples of why he did what I'm about to show you. Here's an example of one of the posts from somebody named Carla. And this is a fair bit of sensationalism. I think that's fair. XRP update. Ripple and SEC just dropped a bomb. In a surprise legal move, both Ripple and the SEC have jointly asked the Second Circuit Court to keep the appeal on hold until August 15th. Until Attorney Morgan read that, you could just tell he's just like shaking his head. You can tell he must have been shaking. It's one of those facepalm moments, you know what I'm saying? And so he says, no surprise at all for those following the case. The SEC was required to report to the Second Circuit by June 16th, and it did. The SEC asked for another 60 days for the appeal to remain in abeyance, as the joint motion for an indicative ruling from Judge Torres hasn't been cited. Right, so we knew this was coming. It did happen. This doesn't mean Ripple and the SEC dropped a bomb. That is a ridiculous characterization. I agree with Attorney Morgan. But it's kind of funny to see what prompted him to put together this awesome comprehensive list of what's actually going on. Here's another example. Somebody named Parrot wrote, breaking news. Ripple and SEC just dropped a bomb. Do you see the word of choice from some people? The bomb is boom, bomb, boom. Like this. It's the boom people. There's the boom people. Anything that happens, boom. In this case, it's a bomb. It just makes me laugh. Anyway, they're asking the Second Circuit to keep the appeal on hold until August 15th with the SEC filing a status report. Is this the calm before the moon? And so Attorney Morgan saw this and wrote, in no way is it a bomb. I love the bluntness. He says the appeal and cross appeal needed to be held in abeyance for a longer period so that there is time for Judge Torres to rule on the joint motion filed last week. And if she grants the joint motion, for the parties to take the final steps to bring this sorry tale to an end. All right, so what's actually going on? Well, this is a perfect summary. And so Attorney Morgan wrote this in a separate post, and this is Tuesday evening he posted this, SEC versus Ripple, how the settlement process is going. Number one, settlement agreement signed by Ripple parties on April 23rd, 2025, and by the SEC on May 8th, 2025. Check. Okay, so that's done. Number two, parties filed a motion to hold the appeal and cross appeal in abeyance and obtained 60 days from April 16th, 2025 to June 16th, 2025. Check. Okay, and so that's why, again, the fact that there's another document dropping specifically about this and continuation of the abeyance, not a surprise. Not a surprise at all. We knew this is coming. Anyway, number three, parties file Rule 62.1 motion asking for an indicative ruling on May 8th, 2025. Check. And actually I should mention this too. So there's another blurb. Let me read this to you. This is from a separate website here, but it's exactly on this because there was a procedural issue with the initial filing from back, I guess, a couple months, whatever it's been at this point. And Judge Torres called them out for it. And so Judge Torres denied the Rule 62.1 motion because it was not the correct procedural mechanism for seeking the desired relief from a final judgment, and the parties failed to meet the requirements for modification under Rule 60B. They have since refiled the motion under Rule 60B, arguing that exceptional circumstances exist to justify modifying the final judgment. Right. So they did it procedurally properly, the second time, certainly. And so that was the more recent news that we got, I guess, a week or so ago, whatever it was. And the thing is, though, in terms of the messaging that they were delivering, strikingly similar to what Judge Torres had already swatted down, hence the concern from multiple XRP attorneys, XRP community members who are attorneys. And so that's why, again, when I showed you that supplemental, the response for that supplemental document that was filed yesterday, that's why Attorney Rispoli was feeling a little bit better because they should have just included that information in the first place. Anyway, number 4, parties obtain indicative ruling from Judge Torres. Denied, procedural error, did not address Rule 60, motion denied. Okay, so that's what I was just referencing a second ago. Number 5, parties file a second joint motion addressing Rule 60, filed on June 12th, 2025. Check. Number 6, SEC updates Court of Appeals and seeks the period in which the appeal and cross-appeal be held in abeyance, June 16th, 2025. Check. Number 7, parties obtain indicative ruling from Judge Torres sought in second joint motion. And then number 8, if indicative ruling obtained, parties file motion to the Court of Appeals for a limited remand to seek the relief agreed between the parties from Judge Torres. Okay, and so part of what would be referenced here, of course, would, of course, include the injunction against Ripple and as well as the penalty, which was reduced to $50. At least that's the agreement that the SEC and Ripple came to. So got to get the rubber stamp of approval from Judge Torres still. Number 9, upon the granting of the limited remand, the parties will file a motion with Judge Torres seeking the relief agreed between the parties. And finally, number 10, following dissolution of the injunction and payment of the reduced fine of $50 million, the parties will file a motion with the Second Circuit Court for the appeal and cross-appeal to be dismissed. And of course, at that point, there's no reason that it wouldn't be. And so that would be the end of this. So if you're wondering how long is this going to take, well, in a separate post, Attorney Morgan wrote the following. If the SEC and Ripple obtain the indicative ruling, the matter should be concluded within the next several weeks. Okay, so we can see the finish line. Now, hopefully this goes well. Because if it doesn't, and Judge Torres doesn't want to play ball, then things just proceed, and that wouldn't be preferable. That would definitely not be preferable. Now, good news is XRP's got its legal clarity regardless, so people like you and I, we're fine. It's not going to impact, I firmly believe it's not going to impact, like even if the worst happens here, it's not going to stop XRP from having a ridiculous blow off top this market cycle. I personally believe that very strongly. So I think we're going to be fine here. Anyway, hopefully that makes things a little bit more clear. I appreciate Attorney Morgan putting that together because that's the only post or article that I've found that succinctly put literally everything you'd need to know to understand what's happening now in one spot. So I wanted to share the message with you. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.